While the formal title of the session upcoming is Access to Justice Through Small Claims in Commercial Courts, I think our discussion may be a little bit broader, but basically encompassed by those mechanisms for economic dispute resolution beyond the ordinary courts. We're going to try and, as best we can, avoid talking about the regular courts. I think there's a consensus that they generally do not work as well as they should. We're not going to fantasize about those things that we would adjust to the regular courts, so we'll figure what kind of solutions that are available outside of that mechanism. And one point I'd note, this is not just an African conundrum by any means. The question is sort of access to justice for whether you're a poorer person or a poorer enterprise or an individual with an economic dispute of some sort is difficult everywhere. The courts are expensive in the U.S. They can be slow in the U.S., and it's the same almost anywhere, except maybe Singapore, but that's an outlier country. In the U.S., it's in some ways, a lot has been addressed by the advent for commercial disputes, particularly between commercial entities, by arbitration. I mean, to give an example, say in construction disputes, something I think in excess of 90% of construction disputes are resolved primarily through arbitration, and it can be very simple single arbitrator arbitration under the American Arbitration Association or other mechanisms, sometimes mediation, increasingly construction boards. But again, construction companies do not want to go to court. There's time, there's money, sort of the delay of project. There's the same issues that are faced everywhere, and it's one thing that's interesting to me that I hope we'll get to talk in a little is that for domestic arbitration has certainly come of age here. It's not always a perfect solution. I'm very curious because 25 years ago, when those of us who were in this sort of development and law space, we sort of assumed that arbitration was very much a next logical step for domestic economic disputes in Africa. And I think with certain exceptions, I mean, a lot of arbitral institutions have been set up within countries in Africa. Very, very, very few are working by more than a very small number of cases per year. It's a surprise to me. I mean, I have my own theories about why it isn't working, but I hope that is something that Yemian is talking about arbitration in Nigeria. Nigeria, a very big economy, and a much larger arbitration institution. But all those surrounding countries, they have economic disputes, but their arbitration institutions are not really working. They don't, in effect, they hardly exist. Again, for the SME side, we talked about that we understand it's just not practical. Even if ordinary courts were much more effective, it really wouldn't be practical because of costs, because of time. I mean, the classic example, if you're a woman who has a market stall outside the High Court in Maseru, and you have a $150 dispute with your supplier, you're not going to hire a $175 lawyer to take that to court in any case, maybe not even to the commercial court. But we'll talk some about small claims. That's something that's very interesting. Commercial courts, I mean, I think Uganda was the first of the Commonwealth countries to introduce that 20-odd years ago, and has been rather successful. I mean, a number of other countries have done pretty good jobs and have taken slightly different approaches. I mean, Ghana has also been pretty successful, and they have developed a strong mechanism to move disputes from the ordinary courts. Twice a year you kind of have a time period where if you're sick of your lack of process and progress in regular courts, the regular courts will facilitate the movement to the commercial court. And so that's an interesting thing as well, and I don't know how many other countries have done that. But a lot of the Commonwealth countries have done it with varying degrees of success. Something that's very interesting to me is that within the last 5 years, basically since I've stopped working in the world of sort of commercial court reform, a lot of civil code countries have created commercial courts. And I have to admit, I don't know anything about the degree of success of those. But I can tell you, 10 years ago, a number of civil code countries where I was working were very resistant to the very concept of a commercial court separate from the ordinary courts. And I'm curious, and I don't have an answer, but I'm curious sort of what tipped the balance. It may be having looked at what has gone on in countries like Uganda and the realization that, these Commonwealth countries are getting ahead of us. Because there's kind of an ongoing debate that some of you are aware of I'm sure, of the business the business significance of the two kinds of systems, civil code and common law code. Again, our process now, we basically have 4 steps upcoming, and we're going to hold the Q&A until after that. You see what looks like a still picture of Justice Mappy Morgan of the Commercial Court in Liberia. She had hoped to join us in person, but was unable to because of workload. And but she's sent a video, and we've just taken a portion of this where she's sort of talking about sort of commercial courts and small enterprises and the interconnection and the value and so forth. After that, we're going to shift to Justice Kirabwire, who will primarily be talking about small claims. But I hope you'll offer a few comments on commercial courts, and particularly kind of the comparative commercial courts. Yemi Kandi Johnson, who is from Nigeria, is a practitioner, a real live commercial lawyer, something I hope to be when I grow up, but is also the president of the Lagos Arbitral Institution. And so he's very expert in that area, and I'm very curious to hear about that specific institution, how it works, how you think it could work better, and also are there lessons for other African countries that have struggled on the arbitration side? Any comments you have on formalized mediation outside the courts? I'm very interested in, because that's something that has not been done that much. As the Minister of Finance had mentioned, the mediation, and it was court annexed in the case of Lesotho, dropped. It basically, of cases, commercial cases that were filed with the commercial court in Maseru, it was just the one court, just over half, at least for the period of a few years when I was following it, just over half were actually able to be resolved by mediation, court-annexed mandatory mediation, which is pretty good. In a number of Latin American countries, where there is mandatory court-annexed mediation before you can begin litigation, a number of countries in Latin America have gotten basically what I call scores of above 80%. And if you think of the impact of that on the docket of regular courts, very significant. And in some ways, you would think that's the kind of thing judges would want to push above all else. I understand the ambivalence at times of lawyers, but obviously the ultimate argument is you're trying to make a bigger pie. And if you can have a more successful economy, there's going to be more business for you. But it's hard to get people, any of us, thinking beyond what our immediate understanding is. And then as we call my colleague Jan from the Bingham Center is what we call in the U.S. the cleanup batter. After everybody else has talked, there's a lot of pressure on him to hit the home run, but he'll be talking particularly about sort of the Kenyan experience. He's done some work there in this space, this sort of dispute resolution beyond the ordinary courts. But I'm going to hopefully click on this, and Justice Mappy Morgan will chat with us for about 7 or 8 minutes.
Enterprises. Despite the low level of investment in Liberia's SME continued to provide local jobs and boost cash flow within the country and reinvestment. Key findings from the market overview report by Building Markets show for every dollar exchanged with local businesses, 78% of it is spent within the Liberian economy on salaries and purchasing local goods and services. On average, contracts won by local businesses reap the following benefits: job creation, 13 full-time jobs and 5 part-time jobs for the duration of the contract. Reinvestment, at least 91% of businesses use profits from the contract to reinvest in their business, and provide additional business opportunities. Of local businesses that won a contract with international clients, 68% won additional contracts in a 6-month time frame. Of businesses that won a contract with local customers, 82% won an additional contracts in a 6-month time frame. We're finding time and again, as we said before, SMEs do have competing priorities and needs, and these are some of the reasons they do not go to court. in an entity that has a small number of staff, they prefer not to get into litigation, which is time-consuming and expensive. Another key factor is a lack of trust and confidence in our judiciary. The Liberian judiciary has gone through a tremendous reform that is still evolving, including the establishment of several courts, the commercial court being one of those courts. A majority of the courts mentioned, some of the criminal courts, deal with cases of murder, rape, and land dispute and injuries. However, in practice, only a minority of those courts or the respondents settle their dispute in our court system. Several questions then were designed to examine further community access and perceptions of the formal court system. Most respondents recognize having 50% or little knowledge of the former court system, and that includes courts, new courts such as the commercial court. And so we find that this continues to be a problem with the populace not knowing that they have courts that they can access in terms of justice. Of the survey, certain questions were asked. For example, do Liberian judges treat everyone equally? 28% of persons said yeah, leaving close to, let's do the math here, 28 from 100, you do the math, but leaving close to more than 75% of persons not really agreeing that we judges treat people fairly. Judges are the same for everyone. Again, 75% of those persons said no. Going to court is expensive. 75% of those persons polled agreed. Do you trust the Liberian court system? 36% of the polling said yes. You trust the Liberian judges? Dismally, it's 31% of people who said they have trust in judges. Going to court means you have to bribe judges. Sadly, 44% of those polled agreed. Liberian lawyers are able to do their work freely, and 30% of them agreed to that poll. You can understand that from these pollings, it is a sad commentary on our judicial system, and we have to do much more to increase access to justice, at least as it pertains to the public perception of how Liberian courts respond to citizens' issues when it comes to justice, to include commercial justice or to include SMEs trying to find relief through courts. We've found over time, over the last 6 years, that a lot of SMEs have been bankrupted, have gone insolvent, so to speak, based on loans that they have taken and they have been unable to pay, but also particularly based on services that they have rendered to government institutions, and these government institutions have yet to respond to the SMEs' request for credits to their accounts based on services rendered. The Liberian justice system or the court system continues to evolve. It is our hope, or the hope of the business sector, that cried out for a specialized court such as the commercial court, that their issues will be particularly handled, will be rapidly handled, and we can say with some certainty that the commercial court has hopefully responded to the business community. Our stats will show that we have a robust pre-trial regime, and during that pre-trial regime or pre-trial conference, let's say, for example, if we had 10 cases on the docket, at least 2.5 of those cases are settled at the pretrial level, which means that the cycle is shorter. So persons coming to court can understand immediately that within at least 40 days that the matter will be docketed and that some voice, some judge will sit on that case either by way of a pretrial conference and the matter will be decided, of course, with the agreement and consent of the parties that, listen, this is a dead matter, this is a action of damages, we agree, we want to sit down, and sometimes the lawyers go back and stipulate that this is how they want to go. So we're finding that the commercial court is at least responding to the commerce sector, and we hope that this trend can continue. And of course, we need all the help we can get, and we're always thankful to our development partners for assisting in this process. So I thank you for inviting me to this conference. I hope that some of the information provided has been helpful, and I hope that with the creation of a specialized court such as the commercial court, that investors' confidence will increase that their issues can be responded to as rapidly as they're presented before court. Thank you very much. Goodbye.
Good afternoon to everybody. Uh, I'm very pleased to be here, very pleased to be able to share with you what we've been doing in Uganda in the area of trying to support access to justice for a lot of the informal sector and those who are in the micro, small, medium enterprises, and how that has been working for us. I'd like to have a discussion with you, try and probably start with a statement of what the problem should probably be looking like, try and look at what we have done to re-engineer the civil justice system, how we have adopted the small claims procedure, the results of those procedures, the challenges, and give you a conclusion. I've also been asked by Stuart to say a little bit about the commercial court. Now, really in Uganda, we're dealing with a civil justice system that was not working efficiently, coming out of many years of civil strife and having inherited a fairly foreign type of justice system out of the UK. Our justice system dates back to 1902, and you'll be surprised that very many aspects of our justice system still reflect that 1902 status. There was a need to try and deal with this issue of making the courts work more efficiently, and especially in the area of civil justice. Now, one of the things that we inherited was a civil justice system where all civil disputes went to one division of the High Court. So whether it was commercial, whether it was a land dispute, whether it was a tort, or whether it was a family dispute, all of them would line up before the same judge in one division. Now, of course, that meant that there was no specialization. It also meant that the courts tended to be congested, and this negatively impacted on commerce and development. And there was a huge cry, especially, and that was the point I was trying to engage the minister from Lesotho. There was a huge cry, especially from the commercial sector, to try and reform the civil justice system to be able to be sensitive to business and commerce. We had interventions from the Uganda Manufacturers Association, the Uganda Bankers Association, the Public Sector Foundation. All of these people were saying, you need to reform. And in 1996, we did reform. And what happened is that we created a commercial court division of the High Court, which is popularly referred to as the commercial court. What happened is that this court was carved out of the main civil division of the High Court. It's a fairly nice building, as you can see. It is IT compliant, and it gives comfort to a lot of the people who are in the business community that you're going into a serious looking outfit. And indeed, also the training that went with the staffing, the justices, was quite intense. And we started to see results coming out very quickly. They were even able to attract people like me. I come out of a very unique route into the judiciary. I am a former CEO of a financial institution. So that also allowed the attraction of people who actually knew what business was about. It was very popular. We started to get very good responses, very high clearance rates. But there was one problem, and that was in the informal and SME sector. And when I talk about SME, I'm actually talking in a much broader sense, both the micro and the normal. A 2004 report indicated that in spite of the fact that we had created a commercial court and there was only one in the country, access for this sector in the capital city was only 44%. And when you extrapolated that on a nationwide basis, then access was 19. And they said, look, you have created a super court for big business, and it's still not working for us. So it was necessary to rethink and find a way to accommodate the bulk of people who were involved in business and commerce. And just like Dr. Kiveruka said, this is where the bulk of our population is employed. This is the real engine of commerce. How do you get these people into the court system when they need to resolve a dispute? And so we thought about it, and in 2003, I was asked to lead a research into the possibility of creating a small claims procedure within Uganda, our own Judge Judy Court, with a Ugandan flavor, not televised, however. So after 8 years of study, we established the Judicature Small Claims Procedure Rules of 2011. What was interesting about this is that we carved it out of the commercial high court and put it into the magistrates' courts, which were a lot more around the country. So the small claims judges were actually the magistrates who were all over the country, so as to respond to the need to have everybody included, not just those who are in the capital city. And what the procedure did was to allow for recovery of monetary debts which were not in excess of 10 million Uganda shillings. That's about 2,700 US dollars. The paperwork was extremely simplified. We simply had a questionnaire which, when filled, would then turn into a pleading which could then be filed in court. The service of that pleading on a respondent would also be done by the court, and it would also have a form, and that would form the defense. Very, very simple. I mean, we pitched it at the level of high school education, that anybody with a high school education in Uganda would be able to fill in that form without any form of difficulty. Central to it was that there was no use of lawyers. The litigants represented themselves before the magistrate. Just like we had out of Lesotho, this was not very popular. The lawyers said that there was a right to representation, and our response to that was very simple. If you really had a client who wanted to be represented, in a matter about $2,700, you take him to the regular track. But if the litigant actually wanted to gain the benefits of a fast track, he would come by himself and argue his case. We had a rule of 14 days within which a decision had to be made. However, the reality was that most decisions, over 90%, were made the same day after 45 minutes of hearing. So this was a big change in the way that court was doing business, and it was very popular amongst this category of informal sector and SME. So what happened was we tried to do a roadshow throughout the country to popularize this procedure so that people were aware. As you had the minister from Lesotho, there was the whole issue of we didn't know that that procedure was there. In Uganda, we made sure that everybody knew that the procedure was available. And this was also unique because for the very first time, the court went to the people. It was very unique to see court staff going into the markets, going into the business centers, giving out T-shirts, giving out flyers, and telling people that you can actually have access to the formal court system via the small claims procedure. We also did a massive amount of training for magistrates to be able to handle this sort of claims. So let us look at the performance. We started in 2013, and we have run up to 2016. So in the first year of our operations, there were recoveries of up to 1.5 billion Uganda shillings. That would be the equivalent of about $417,000. And when you think about it, people are making claims of about $200, $500, $1,000. Those are a lot of cases that cleared the system. We started with a pilot project of 6 courts that was built into 25. And by 2016, which was just last year, recoveries recorded were 8 billion Uganda shillings, and that is about $2.2 million. And this is just out of 26 pilot courts. We are just under 1/3 of the courts in Uganda. So you can imagine if you extrapolate this onto the rest of the courts, the kind of recoveries that can be made. And immediately you could feel the change that was happening in these areas where these courts were operational. The respect for enforcement of contracts just simply went through the roof. And the call for the rollout has been tremendous. And we continue to record a lot of gains out of this particular procedure. When you look at the type of litigants who are coming, clearly were able to show that it was not the middle class who were coming into the courts. It was those sort of people who we had targeted. You can see that really the graduate group only amounted to 12% of all people who were actually going into these courts. And talking about gender and looking at how the type of business community was accessing the court as well, that was also an interesting statistic because there are a lot more women in the informal sector and in some of these SMEs. And we were able to find out that for about, the ratio was about 3-to-1, 3 men to 1 woman actually coming in. So every 4th person was actually a woman filing a case. Of course, that needs to be worked on to equalize it, but I think it's a good start for the amount of time that we've been able to run this small claims procedure. Now, we did a baseline study last year using consultants out of the UK, Laser, and the LDP group, and they found out that the annual disposal rate of all claims was 86%. So really, out of all cases that were filed, 86% of them were disposed of. This is critical because when you look at the type of cases that went through the normal civil track, you will not get that kind of statistic. And more importantly, there was absolutely no case backlog in the small claims procedure. The mean lead time from filing to disposal was 42 days. This compared extremely favorably to the about 4 years that it would take for you to get a disposal in the main track. And it was therefore not surprising that immediately there was a 55% decline in the filing of claims in the regular court track for equivalent amounts. So the procedure was able to sell itself in the sense that people very quickly moved out of the regular courts and started filing by themselves and arguing their own cases in the small claims track. This was also quite interesting. The report indicated an 80% satisfaction rate for court users. You'd be hard-pressed to get that kind of satisfaction rate in the civil track. We have had a lot of interest in other countries coming and trying to study this model. Of course, you had what happened in Lesotho, but there are other countries where it has been more successful. We still have a challenge of funding. We have a good innovation here, but we do have a challenge in funding. And this is one of the areas where we really want to engage. The government has tried as much as it can, but we really want to engage with development partners as well to see that we can get this funded throughout the country and therefore have even a bigger impact on this sector of our economic performers. So it did not come as a surprise that in 2013, in the first year of our operation, the small claims procedure was voted the best innovation process in Uganda for that particular year in the winner category. Again, the only award in that category that the Ugandan judiciary has ever got. So we're pretty proud of that achievement. So really, I don't have much more to say. I do have a copy of our annual report. If anybody would like to read it, I do have a few copies. I'll probably leave them with Stuart, and anybody who's really interested in seeing, learning more. There are more stats in there which you may find interesting. Thank you very much for your time.
Hi. Good afternoon. Thanks very much for this invitation. It's always a pleasure to come to this great city. Thank you to the Bingham Center. Thank you to Jones Day for the event and for your hospitality. I am a practicing lawyer, commercial lawyer, like you'll be when you grow up. And I'm also the president of Lagos Court of Arbitration. Of course, I prefer to introduce myself as the chairman of Lagos Court of Arbitration because it's the title president is a bit grand for the total lack of ceremony and fanfare that is associated with my office. But the Lagos Court of Arbitration was the result of an effort by the government of Lagos to influence the business environment in Nigeria, starting from Lagos. It's a responsibility that the Lagos state government takes quite seriously, and which is quite important. Lagos is, and someone said to me recently that I always seem to introduce myself as Yami Kandi Johnson from Lagos, Nigeria. Why do I need to mention Lagos? Well, I guess it's just in the back of my head. Lagos was actually a country before Nigeria was a country. So, and people in Lagos tend to be rather offensively proud about that. Anyway, the fact is that Lagos is like 0.7% of the land territory of Nigeria, but it has over 10% of the population. So it's quite a significant part of the country. It's responsible for 60% of the non-oil economy in Nigeria. It's the GDP of Lagos State is larger than the GDP of Ghana or of Kenya. So it's quite a significant little tiny place. And over the political history of Nigeria, it's been recognized that much innovation comes from Lagos, and that also in the system of justice and its administration. So this was the type of obligation or responsibility which prompted a progressive governor of Lagos State to set up a committee in 2007 to look into the alternative dispute resolution and the part that Lagos was playing in it, not just domestically, which is the focus of my responsibility right now. This is what is interesting to me. But the governor then also felt that it was important that because of the high level of activity generated in Lagos, 2/3 of all economic activity in West Africa starts in Lagos. And because of a lot of that activity was then being arbitrated in London, in Paris, and in other places, there were losses to the economy of Lagos, not just because of the work that wasn't being given to arbitrators, but because of the loss of hotel accommodation, food, that sort of thing, the whole ancillary activity. And we felt it was important for us to try and capture as much of that as possible. And that to do that, you have to present a high-quality product in terms of the facility, high-quality product in terms of the solutions you provide, the skills and the ability of the people who would be executing them. So this was the challenge. In 2007, I was the chairman of that committee, although ultimately the product of that committee's work was the Lagos Court of Arbitration and a 2009 arbitration law in Lagos. I'm only the third president of Lagos Court of Arbitration, so it wasn't like I rendered the report to put myself in an official position. Anyway, and what we've been doing is we have an administration for dispute resolution. We have rules for arbitration. We have expedited resolution procedures. We have arbitration mediation rules. We also consider a major part of our work to be in training. We've done, with the support of international organizations who have funded the costing of it, training judges as to how they should approach dispute resolution, how they should deal with challenges to the procedure, how they should support the procedure and their responsibility to do so, and the importance of that support in the commercial context and for economic progress of Lagos State. We do training schools for arbitration and for mediation. We do outreaches. We have had a number of engagements with the entertainment industry, which has resulted in us preparing rules for this specific type of disputes that they have in the entertainment industry, and dealing with questions of costs and dealing with question of the understanding and the accessibility of the participants and the users to the processes that we're administering for them. The necessity for this sort of engagement becomes very important when you consider I wouldn't say a disaffection, but somewhat an alienation. I really do think, and it's difficult for me to say because I come from a judicial background. My father was a judge, my brother is a judge. But I just don't think that, I don't know about red judges anywhere else, but I don't think that red judges in Nigeria do much for commerce. It's like it's only in 1863 that the courts of the King of England were established in Nigeria. And for centuries before that time, commercial disputes and a variety of other disputes were decided in a traditional way. In fact, in Lagos, and as I like to tell people, even at a time when it was a mosquito-infested swamp, where human sacrifice was rife and slave trade was the major commercial activity, businessmen, so to speak, decided the disputes under the palm tree and in the garden of the King's Court. So there has been a long tradition, historically, which is mirrored across the country, for deciding disputes in a way that allowed the people to voluntarily adhere to the result. There were traditional societies in the East. There's the Ekpe Society, there's the Boni Society. These are societies of people which were founded in the economic interest of the society, which were based on economic progress, and which had committees for deciding amongst people disputes. And basically, those disputes were resolved effectively, promptly, and without much question. The English courts, which, as I prefer to call them, were established in Nigeria to execute the protection of the economic interests of the King of England within Nigeria. That is the purpose for which courts are put in colonies, to be sure that you can administer it in a way that allows economic advantage to filter in an appropriate way and to control it. And this was the purpose. But then when Nigeria was no longer a colony, I think that some of the emotional and psychological commitment which is required to sustain a system of dispute resolution, a system of law, was gone. So we have the huge drama of judges in red robes and in horsehair wigs still presenting themselves, and you have much of the tradition of the English courts being mimicked. But I don't think that's my personal opinion, that the substance of it is as potent as it would be, because the people are threatened and intimidated by that system of courts, and this was the original intention. I remember when I was a child, and they'd have their sizes, and all these red tunicked soldiers marching, and it was a huge drama. And when their sizes were going on, everybody knew you had to. The idea was to demonstrate in a dramatic fashion the force and power of the king's law. I wasn't this cynical when I was young. As I grow older. Anyway, and so this was the idea. So it was clear that not only because of the congestion, because of the difficulty of the procedure, because of the obsession with procedure and technicality, that the mainstream courts weren't deciding cases in a way that were effective and which were easy to accept by the people over whom they were operating. So this is very important what we're doing. So this is why, having established this Lagos court, part of our challenge was to then present ourselves to members of the public, people in trade, farmers, entertainment industry, hospitality. We do mortgages. We are not only administering and advocating for alternative dispute resolution, but we are also creating models, because by engaging with specific groups, we understand what type of problems, we understand what type of language they understand, we're creating specific forms. So we have a form for the Lagos home mortgages is inevitably the largest home mortgage system in the country. And we've created the system so that both the mortgage board and the mortgagees can resolve issues between themselves very swiftly. And then you talk about 14 days in the commercial court. So also was this procedure meant to be achieved within 14 days. And in many ways, and we will engage wherever we're invited to engage. We have been to Alaba Market is a major hub for spare part trading in Nigeria, and we went there. It's not a place where you appreciate men in suits. So so distinguished as the arbitrator may be, he would be in jeans and an open-neck T-shirt and a cap. And we try to talk to these people, and it's fascinating to realize from the work that we do and the study that we have undertaken. I've learned so much about how people resolve their disputes. In many respects, the hostility and the arcane procedure of the traditional courts have isolated them, and in many respects and in many aspects of Nigerian business rendered them irrelevant. Even multinationals would rather go to arbitration than go to those courts, because you can't guarantee the procedure and the person who you're dealing with, nor always the integrity of respective judges. But so we have taken it upon ourselves, and this is part of the work that we're doing is developed from the things that we're learning from people. So they want specific type of solutions. They understand specific, and so we create forms, we create shortened procedures, and a variety of activity, including, as I said, these outreaches, explaining what we're doing. I was interesting to hear that you had a road show in Uganda, because it's something that I think that a road show across Nigeria, because of the complications of road transport, may not be as convenient as in Uganda, but then it's something that we have to do. I mean, I was invited to do an arbitration recently in Ekiti and got into a big fight because I said Ekiti is 6 hours away from Lagos. And I was considered too snooty because I said I wasn't going to get into a car and drive for 6 hours to do an arbitration. So it's a lesson that the work that I'm doing, because it's voluntary and not paid work, it's a responsibility. So I guess for the purpose of Lagos Court of Arbitration, I would have to drive 6 hours or 8 hours or whatever was required, or I wouldn't do it, because for purposes of income, I guess. But the important thing, I think, is that I think we are gaining traction. I mean, I won't forget the point you made about formalized mediation, because there's something that is a process that Lagos, even outside Lagos Court of Arbitration, is attending to. Maybe I should mention that first. Then, apart from the Court of Arbitration, there are a number of other institutions. There are associations of arbitrators, construction arbitrators, there's banking arbitrators. I'm not really thinking now about the arbitrations in banking and in construction and oil and gas. Those will resolve themselves anyway because these are sophisticated parts on either side. They have large, deep pockets and they can fund a procedure that is suited to them quite quickly. But then the type of work that is required by the lower levels of people is a larger part of the commercial activity across Nigeria than that which is resolved by banks, etc. But to go back to the point I was making about formalized mediation, we have in Lagos an institution called the Citizens Mediation Center. That was established in 1999 by the Lagos state government, and this deals with landlord and tenant matters, and it deals with family disputes, and it deals with chieftains disputes, and they decide thousands of cases every year. In fact, they had a celebration of their 25th anniversary, I think a couple of weeks ago. I was at this event, and they're justifiably proud of the fact that people, local chiefs and traditional individuals are willing to come and talk to them, and the accessibility is so important to the effectiveness of the system, and these are people, like you say, the people who do have $200 claims are poor people who have minimum education and minimum confidence to express themselves clearly in a highly stultified and formalized environment. So the Citizens Mediation Center has effectively a formalized and permanent mediation center which people go to, and it seems in Lagos to be working quite well, which I consider will be a model for the rest of the country. That we have a multi-door courthouse, which is next to Lagos High Court, which is also established by law, and that also provides mediation and arbitration and a number of people who provide facilities for resolving small and that type of minute dispute. So I suspect that my time is over. So this is I just want to give a general idea of what we're doing. Outside there, I'd strewn across the table several flash drives which contain 3-minute and 5-minute videos about what we're doing, as well as our rules and procedures. If anyone's interested in picking one of those up, they're out there. You can look at that if you have the time. Thanks very much.
Thanks, Yemi. Much appreciated.
Thank you, Stuart. Good afternoon, ladies and gentlemen. Unlike the two panelists before me, I'm not a commercial lawyer. I work on constitutional law at the Bingham Center, and I don't think I've spoken in any setting quite as magnificent as this, with all its nice constitutional scenery. So thank you very much to Joan Stay for hosting me. I think that's not my first slide, so I'll take you back to the beginning. I will be talking about the rule of law need of SMEs to have access to justice, and what is being done in Kenya in an era of what I call justice sector reform. And my experience of Kenya goes back to 2009 when I first went there to work on a project, and I've worked on a few constitutional and judicial projects since. So by way of background, I thought I'd ask the question, which Kenya are we talking about? Because in the media, there are very different stories being told about Kenya at different times. So on the one hand, we have the regional economic powerhouse of East Africa, a place where, as Anton mentioned, there's a recognized fintech hub and more generally a lot of IT activity. Crucially, that economy is not an extractive resource-based economy, unlike many in Africa. So there would seem to be this economic beating heart of the region. But on the other hand, we have Kenya as a troubled place. At the moment, of course, there's an election that seems to have ground to a halt, and all eyes really are on what will happen there. But there's a history of problems like that. One speaks of the politics of patronage, of elites vying fiercely for the economic resources they can extract, and so corruption, of course, a very big challenge. And one might expect that sort of environment to be quite hostile to the SMEs. So what I'll try to sketch in this presentation is what is being done now, and a sense of really what the outlook is for the SMEs that are clearly so important to Kenyan economy and society. But I'll do this as a lawyer, and I'll have to say not only constitutional lawyers would say this, but almost all Kenyan lawyers would say that the Constitution of 2010 is the most important thing that's happened to the Kenyan legal system since independence. So it didn't come quickly or easily, but after multi-party democracy and other reforms in the 1990s, there was a very long process of civil society getting together. Eventually, the government in the early 2000s gave them a formal platform to develop the content of a new constitution. The result is regarded as one of the world's more progressive constitutions. And then you may ask, well, what does a constitution have to say about SMEs and anything particularly relevant to them? Usually constitutions are not so concerned with these matters. But I think in the chapter on the judiciary, there are some important principles that both reflect the concerns of the Kenyans who shaped this document and also gave a kind of platform for further change. So this is the one clause that I thought I'd reproduce. And in particular, if we look at the principles, there are some recognized ones. Justice shall be done to all, irrespective of status. Justice shall not be delayed. Those are probably as old as Magna Carta. But some interesting further principles. In C, we have an explicit constitutional recognition that alternative forms of dispute resolution should be promoted, and that includes both the traditional forms which are at community level and not state-sponsored law, but also business mechanisms not purely based on courts. And then I find D even more interesting and expressing the frustrations of many, including, I think, small businesses, where it was laid down that justice shall be administered without undue regard to procedural technicalities. And I still wonder sometimes whether this isn't quite a useful tool if you're a lawyer in court in Kenya to move things along. Notoriously, cases would take a long time, and for in the same way as some of the other jurisdictions we've talked about, it could be for procedural reasons. So this was recognized right there in the foundational level. But the Constitution was only the start, really, because there's been a period of implementation since then, and I think some very encouraging things are happening against a background of a politics that hasn't really changed. So there's still patronage as the way of life in politics, if I was to simplify, and things are happening that deal with some of these challenges of the SMEs. So this is really, as I've already suggested, problems like delay and complexity are serious issues in that area. But while not explicitly mentioned in that part of the Constitution, serious judicial and more general court system corruption has been recognized in Kenya as a major problem. And the country's tried to deal with it, certainly over the past couple of decades. So here is what is going on at the moment. I've highlighted only a few of really an astonishing number of developments in a short space of time. The first is one that I was involved with as a consultant because of my interest in the courts, and I happened to get some of my papers to the people who were setting up a body required by the Constitution. And in a way, the finance minister earlier mentioned that Kenya has tried something unusual. Well, they put a limit on how long chief justices could serve, but in fact, they made all judges and magistrates undergo a suitability inquiry known as vetting to see if they should keep their tenured positions. And so I was a technical assistant for that. And just a couple of stories there that are relevant to why the legal system isn't exactly SME friendly. of course, corruption was the thing people most wanted to solve through this process, but very hard to prove. And so suitability was defined more broadly, and there were questions of how competent judges were, also of their attitude to litigants. Some judges were judged unsuitable because of their disparaging attitude to poor people and comments to them in court, so that unfriendliness was even taken as a ground for saying someone couldn't stay. But here, as an example of what a judge could do to harm the business climate, one of the judges excluded through this process had heard a claim from big business, from insurance companies, ex parte, without any other side present, and ordered that all payouts be stopped from those insurers across a broad range of claims. Now, the reason she gave was that there were some fraudulent claims, but it's not hard to see that this swings things very far over to the other side. So if you're a business trying to stabilize your position and protect yourself against contingencies, that was gone because big business had rather surprisingly won this case. And the vetting process allowed the vetting authority to say that if judges couldn't really explain their conduct, they would sometimes be judged unsuitable. So that was one outcome. But on the bigger issue of delays in the court system, it was very hard for this process to fix matters. And initially, 3 or 4 judges were considered unsuitable because they had delays that seemed to be their fault. So they were delays in delivering judgment. It's not getting to court or case progress, but delays sometimes going into a number of years in delivering a judgment once proceedings had concluded. So one might have thought that that was a very clear basis for removing those judges. But in the end, they all managed to convince the vetting authority in their review applications that they should stay by pointing out that they were working in a chronically underfunded court system. One of the judges said, well, I just have to keep hearing cases so that the public knows the doors of the courts are open, and I end up with far too many. Now, that for me was a very clear sign that this process, interesting though it was clearly not going to build up a properly functional legal system all on its own. So there have been many other things going on which I think are moving Kenya towards that. The central structures within the judiciary were really strengthened by the Constitution and then by how they were implemented. So instead of an all-powerful Chief Justice, there's a Judicial Service Commission with the right mix of people, judges elected by their peers, the bar, and so on. But crucially, not only do they have the usual responsibilities, but they could also set the agenda for the judiciary to some extent. Some very comprehensive frameworks were adopted for what needed to change in the court system to make it meet these lofty constitutional ideals of access to justice. I'll get to some of the measures in a moment. But fortunately, again, there has been funding forthcoming from 2 main sources. The one was a clever constitutional provision which made the judiciary present its budgets directly to Parliament, where then instead of an official just arbitrarily starving the judiciary of funding, the courts could now lay out what they needed. And this has resulted in things like tripling of numbers of judges to a more acceptable level by international standards. And the other is, to my knowledge, the biggest commitment to date by the World Bank in a justice sector project. Well, certainly it would be in Africa, but I'm told one of the biggest altogether. $120 million. And this funds things like building or refurbishing courts, and the impact there is measured by how close the courts are to Kenyans. So the rural areas are now much better served. Access to courts also promoted through measures like court user committees, legal information, websites for Kenyan law, but also in the commercial sphere, commercial law guide has been written for judges and magistrates who may not themselves be specialists, and for anyone to use. It's made public. Backlog reduction through targeted clearing of old cases and putting judges on teams to do that. Performance management, case flows, and it's all done electronically as well. So really, there's a lot going on, and I will just give you some of the highlights of changes in the system that are particularly beneficial or relevant to SMEs. These are the three main points. The commercial courts in Kenya also go back to the 1990s, but in the beginning it was just a division of the magistrates' court, so dealing with claims only within a limited financial jurisdiction. And again, the Constitution provided the opportunity to reorganize matters. There's now a commercial division, and it has 6 judges. But in a way, it's a victim of its own success. So it's got a backlog, which, as you can see, is quite serious. I would draw attention to the 2,000 cases over 5 years old. And also, there's the challenge of expanding this kind of court beyond the capital. So at least the backlog issue is now being tackled to some extent by court-annexed mediation, which has been running as a pilot project since last year. And it's quite a tough procedure, really. So the mediation registrar assesses the cases. Parties can be required to go to mediation. It has benefits for them in being free, in finality, in the sense that just like arbitration that would be covered by arbitration legislation, the decision is binding and they're not subject to appeals through the court system. And mediators may even police the conduct of the parties and report to the court any sort of obstruction of the process. It is apparently achieving some success. The numbers for cases may be relatively small in the larger economic picture, but I think the speed of disposal is a very significant gain, really almost 2 months down from 2 years. So this is an initiative that obviously, if successful, could be scaled up. And then finally, small claims courts. Now again, they've only just made it into the legal system in Kenya and are still being implemented, so I don't have those sorts of statistics. Many similarities you'll see with the Ugandan courts, a similar sort of financial size, an emphasis on local dispute resolution. Kenya's new system of government since 2010 also has a big emphasis on localism, 50 odd counties. And in contrast to the Ugandan system, where it's magistrates who do the cases, here someone can be designated an adjudicator if they have 3 years experience as a lawyer, or even if they don't have a law degree, but they've got the right kind of paralegal training. So this is an attempt, obviously, to widen the pool of people who can handle these cases. The procedures are very flexible, no lawyers, and the language also doesn't have to be English. It can be Kiswahili, which is a common language in many parts. So it will be interesting to see if this has anything like the impact in Uganda. And the note that I wanted to close on is that the 3 initiatives I mentioned for SMEs in Kenya are not particularly groundbreaking. We've heard about some of them in the other jurisdictions, and it's not only Uganda, but Tanzania, other countries that are not economically as prosperous as Kenya have tried some of these things before. But it's very encouraging that this is all happening now, and I think it's because of the real momentum given to access to justice by the constitutional reforms and then the funding that was injected. So That's my summary of what's happening there. Thank you.
Thanks, Jan. We've got about 10 minutes for some Q&A, and I'm going to cheat and ask a couple quick questions first. Well, this is a bit in the weeds. I have a question for Jan. I have a quick question for you. I'm curious why the decision was made for the registrars to screen the cases that would go to mediation rather than sort of just automatically. Do they figure that they can tell what are more amenable to decisions, or?
Yes.
Oh, you're going to need to. But just talk loud till then. Yeah. You can.
I think it's on. I was looking into that, and it seems that they want to bring in alternative dispute resolution experience. So the registrars have been instructed to use international standards of what's appropriate for mediation. So I guess it's probably an attempt to get something new taken up more than if parties were left entirely to choose it.
No, but okay.
Yeah.
So it's just, but how do they decide some are more likely to be mediable?
As far as I could work out, I was
Yeah.
looking into this very question,
Yeah.
and that seems to be.
But for them, it is mandatory. If the ones they select, the two parties must at least attempt mediation.
Yes,
Okay.
yes. So it's a filter. I guess it's a way of making best use of this new facility. So it's not quite as mandatory as we heard the Latin American
Right.
model, but if the system judges it appropriate, then yes.
Thanks. Nyemi, I had two quick questions for you. One, could you give us a very brief, some numbers about what's the kind of volume of cases per year that goes through Lagos Courts of Arbitration? What's kind of typical value that the LCA sees, and what kind of speed do they typically get resolved?
Well, as far as volume, there's a wide variety because we're doing not just cases that are under our rules, we're also administering
Of course.
arbitrations.
Yeah, but I'm
private.
the whole thing is fine.
I don't know. Some of these cases are they're cases going from 3 million naira to 2 billion naira. So this is what is.
No, that's fine. But do you have 50 cases a year, 500 cases a year, 5 cases a year?
Close at the moment to 50 cases.
Yeah.
Yes.
Yeah, 'cause that's pretty high. And then sort of a follow-up question. I mean, in a way, you're in the relatively early stages.
Yeah.
Why do you think in so many other countries, a lot of these arbitral institutions that have been set up are seeing like 2 or 4 cases a year after being in existence for 5 or 10 years, after having years and years of development assistance funds and technical assistance sort of lavished on them? What do you think could be done to up that rate? What do you think is there a missing sort of potion that hasn't been
Well,
discovered?
from our perspective, I mean, the combination of the disenchantment with the courts, the fact that courts have been so intrusive in people's businesses, the fact that a high degree of economic activity is going on, which inevitably produces disputes, and the fact that the people are pretty contentious. So there's a market because the solution is provided to a surge of activity. So that is one thing. But I think that it's back to the point I was making about the accessibility of the system of justice. People understand that if you go to the traditional ruler in a village, that he has some sort of authority, if not legal, he has moral authority, and people therefore defer to him and his ability to decide the disputes. And that's the same thing. I don't think people have felt, with regard to new institutions, and I consider the ordinary courts to be new institutions as well, people have a difficulty in approaching them. And I think that that's what needs to be broken down.
But I'm talking about arbitration.
Yeah.
Just
okay.
arbitration.
Yeah.
Why is it? Because some people would argue that a system of arbitration is much closer
Yes.
to the traditional system of justice.
Yeah.
If that's the case, why is the uptake so abysmally low? I mean, I think, as I was saying, 20 years ago, people assumed that this would be because of those difficulties that you've well described in the courts, that, well, if it's so bad in the courts, ergo, arbitration will be more popular. My basic question is, why is it so unpopular? I don't mean Nigeria particularly, where it's
I
coming
think
off.
that people don't know. I mean, because in Nigeria, certainly in my experience, I found that going to people and explaining to them what you do, this is why I found the idea of the roadshow attractive, because you need to tell people, in markets, people are surprised that such a thing exists.
Yeah, and presumably you need to have, in the contracts, you need to have a dispute clause
Absolutely.
saying you must do it, because in any given dispute, one party is going to rather not do arbitration.
So you have to start from the beginning. For example, with the Lagos mortgages, we at the time the Lagos mortgage scheme was established, we persuaded the government to write in arbitrations referring to Lagos Code of Arbitration into the contract. So those are generating
So they'll start
themselves.
generating over time.
And so if you start a contract, if it's not a buying and selling contract, it may take 2 to 4 years for a dispute to mature. So you have to start building that reference well before the dispute arises.
It startled me in a lot of the arbitral institutions that I've worked with, in sort of within a single country. There's been a hesitancy to try and push the clauses, because I think there's just this magical belief that if we're here, build it and they will come.
Oh, no.
But it's absolutely not the case.
Although people, we've had people voluntarily submit after disputes have arisen. But really, if you need to lock them in from the start, and that involves you have to persuade the people who are signing the contracts that this is a system that works and that they can rely upon.
Right. Thank you very much. Sorry to do that. Questions from the floor.
Good afternoon again, Chinyere Ban, and thank you for this very distinguished panel. My question is for Yemi about the Lagos Court of Arbitration. I'm wondering about, I know that the arbitration, it seems to me that the main benefit is that you get swifter justice, you can have a swifter resolution of your cases. But I'm wondering whether it's actually cheaper and whether the SMEs are able to access this system. I'm wondering if you can tell us a little bit about that.
That's very important. Arbitration can be extremely expensive. As I said, at the high band, obviously, sophisticated and deep-pocketed individuals. But with the people we're talking about, for example, when we had the entertainment roundtable, and we've had, this year, we've had one more or less every year. And many of these small artists are saying, they've had a dispute and then they had a case and someone asked for 6 million naira. And I'm not sure what the conversion is, but it's $500 to 500 naira to $1. And in many cases, that's just the end of the dispute. So we have to design processes that are simple for whoever will decide so that he can spend the time. And you have to design something which allows you to moderate to a high degree the cost. I mean, something like many of these cases, we've made it clear that 100,000 naira is sufficient. So keeping down the cost is a key aspect of giving people access to the system. So that's something that we notice, and all the time we're watching that.
Yeah. Just a quick follow-up. I mean, I suspect there are AAA arbitrators somewhere in this room, but I mean, it's my understanding that for certain very lower value disputes that go to arbitration, they will provide pro bono arbitrators. There may be some small administrative fee, but it's not like a huge arbitration where there's both the large fees for the arbitral institution and very expensive costs for the arbitrator.
And that's something that we have agreed. We haven't done it yet, but it's something that we have agreed to do.
Great next stage.
Yeah, provide 1 or 2 days a week, and many of these disputes, many of the experienced arbitrators could decide 10 or 15 of these cases, basically with the form. We've designed forms that allow you to be able to record the decision in a way that is conforms to the law, so it's quite effective.
Thank you. Yes, sir.
Thank you. Thank you, Stuart. My name is Matthew Murray, and I was, up until January, I was the Deputy Assistant Secretary of Commerce for Europe, Middle East, and Africa in the Obama administration. And I'm here today as a board member of a group called the Center for Business Ethics. My question is really in the nature of an observation about where this may head, where this may all lead. And it goes to something we worked on when I was in the last years of the administration. We started trying to develop the idea of using specialized anti-corruption courts in different jurisdictions where they may be aligned with the legal culture, with the legal reform strategy of the country, and where they may actually add value as opposed to getting in the way because there's something new and shiny and different. But instead, we looked at whether we could organically put them into the reform packages of different countries. And this idea has begun to take root in different jurisdictions. There's a hot debate about it in Ukraine right now, where they actually went to the point of having a third-party legal commission in Venice look at whether this was constitutional under Ukrainian law to do this. But the reason I mention it is because in so many cases, small businesses in particular, if they are the victims of corruption, and they also have the burden of proof of proving, of demonstrating that they've been victims of corruption, it really does completely undermine justice and adjudication. So it may be, as you develop your different reform programs, it may be something that's worth looking at. It's very dependent on the facts and the legal culture. So.
Thanks. That's very interesting. Ejin, as you probably know, and if there are any bank people still around, I know that the bank has put a great deal of effort over quite a number of years now into the issue of corruption courts. And I've been to various sort of conferences at the bank, and I know that a lot have been funded on the corruption court side. Yes, I think we have time for one more, if it's quick. Going, okay. Sold to you.
So,
Thank you. This question is primarily directed to Justice Kiriabois. Sorry if I've
It's hard for
mispronounced it, your name.
Justice Jeffrey.
Justice Jeffrey.
call me Justice Chair.
You mentioned the informal sector in most African countries, just about all. It's the large sector. Were there concerns from Ugandan citizens regarding the possibility of monitoring or future taxation? Were they to use the court system? And how did you get around these fears, alleviate them, in order to get them to trust and utilize the system?
Yeah, certainly the informal sector, one of the things that keeps them under the radar is the fear of taxation. Not just that they feel that the taxation is something they cannot navigate, but in some cases, multiple taxation, different agencies, and also just a whole question of whether the tax is fair. The good thing about the procedure that we set up, it seemed not to significantly put them above the radar, and I reckon this is simply because of the speed with which the procedure provided a resolution for this category of people. Personally, I do not feel that it is a problem of moving into the formal sector. I think a lot has to be done by the government agencies in order to provide confidence and mechanisms by which many of these informal business sector can go above the radar and continue to pay taxes. And I also know that even though they do not, especially with the main Uganda Revenue Authority type taxes, which is the main taxing body, a lot of their kind of business is subject to what is called presumptive taxation. So in order to get basic licenses, no matter how big your business is, you just pay a flat tax every year. This is very common, especially, for example, in the taxi industry. It's very difficult to know how much they earn, but in order to get licensed, they simply pay presumptive tax, and they seem to go with that. I don't know if that answers your question. I just wanted to make two quick comments. One, when I was in the commercial court in Uganda, we also had embedded within the commercial court an organization called CADA, which is Center for Arbitration and Dispute Resolution. So it was one of out of our multi-door setup, if you wanted to do arbitration, you could go through to CADA. One of the things that we did realize is that most of the cases that went there were mostly those of investment, construction, and that kind of thing. Very little SME was going into CADA. And I think one of the biggest disincentives was the sheer cost of paying the arbitrator. It was a fast track, but the cost to the SMEs was a little bit high. Also, we do have in Uganda, we have established an anti-corruption division of the High Court, which has been carved out of the criminal division so as to specifically fast-track white-collar type crime which also may get into the areas of cyber crime, very sophisticated type of crimes that would need a level of speciality. So the whole concept of specialization is certainly taking root in many African countries. I just thought I would throw in that 10 cents as well.
Very good. Thank you very much, gentlemen. Much appreciated. I guess a 10-minute break.